Good morning, members. Welcome to today's meeting. This is the appointed time and we have a quorum. So I call this meeting to order. Item 1, election of Deputy Chairman. The Secretariat already informed members before the meeting that one valid nomination has been received. The member so nominated is Mr. Stephen Ho. According to Appendix 4 of the House Rules, the members agree to elect a deputy chair. The answer is yes. So I declare that Mr. Stephen Ho is returned as deputy chair of the Subcommittee on Food Business Amendment Regulation. Item 2, application for late membership of the subcommittee. Ms. Judy CHAN and Mr. Perry Yu wrote to the subcommittee respectively applying for late membership of the subcommittee. Please refer to the relevant letters set out in the agenda. Now, according to House Rule set at paragraph 23b, is for the subcommittee to decide whether the application for late membership should be accepted. So any views? No? Well, let's welcome the two new members. If there are no further views, the subcommittee formally accepts the application for late membership of the subcommittee submitted by Ms. Judy CHAN and Mr. Perry Yu. We now have 15 members in this subcommittee. Item 3. Now please note that this subcommittee will examine the subsidiary legislation, and that is the Food Business Amendment Regulation. The subsidiary legislation seeks to empower the Director of Food and Environmental Hygiene to grant permission to food premises for dogs to enter. So for background information, please refer to the Legislative Council brief issued by the Environment and Ecology Bureau and the Food and Environmental Hygiene Department on the 11th of March 2026. And also the Legal Service Division report LS 13/2026, as well as the background brief prepared by the Secretariat, and that's CB bracket 2381/2026 bracket 05. Now, before we begin, let me seek members' views on whether we should conduct a public hearing to accept views from the public. Let me also invite the administration to explain the consultation they've conducted and the sector representatives that they have received. I'll give the floor to the administration now, Ms. Ivy Law. To answer Chairman's question, we consulted the representatives in different sectors as well as organizations. We have, for example, organizations of the catering industry, the West Kowloon Cultural District, Science Park, as well as shopping malls that mostly welcome dogs. We also consulted the Federation of Insurance, as well as animal welfare groups, and also another organization representing frontline staff of the catering industry. Now, we held 8 to 10 consultation sessions, and we also consulted the panel of this council, and we have garnered your general support. Thank you. Now, so much for engaging the public and collecting views from the public. Any views, any comments from members? All right, please press the button if you want to speak. The mic will be switched on, and what you say will be put on record. Right, Mr. Dennis Leung. Thank you, Chair. Now, this is a rather important policy. I hope that members of the public will have a chance to add their views in the form of written submission or otherwise. Mr. Kitson Young. Thank you, Chair. I share the same view. Deputy Secretary already explained the efforts in engaging different sectors to collect feedback. But also, like Mr. Dennis Leung said, I think this is a matter of public concern. So if we're able to hold to invite public views openly, we'll be able to consider the views more comprehensively. Now, my take is that, as explained by the Deputy Secretary, the administration already consulted the sectors quite extensively. Now, this regulation has remained unchanged for over 30 years. So I think there is room for public views to be received on the amendment regulation. So I also support other members' views, and that is to accept public views in writing. Any opposing views? Right. If not, then I think members are in support of the idea of inviting written submissions from the public. The Secretariat will post notices on the electoral website, as well as informing the 18 district councils. The submissions received will be forwarded to members for reference. They will also be forwarded to the administration for a consolidated response. Next. The subcommittee will first discuss the policy issues relating to the amendment regulation. I will now give the floor to Ms. Ivy Law, the Deputy Secretary for Environment and Ecology, to speak on the subject, and then I will invite members to speak. Let me walk members through our legislative proposal. There are a number of aspects. I will first explain the background and the justifications, and they are as follows. At the moment, apart from blind dogs or dogs for law enforcement, no person shall bring any dog onto food premises. No person engaged in the food business shall knowingly suffer or permit the presence of any dog on his or her food premises. Currently, the contravention attracts a maximum penalty of level 3 fine, that's $10,000, as well as a daily fine of $300, as well as imprisonment of 3 months. We've reviewed a number of factors, including public health protection, market acceptance, market demand, etc. Now, the Chief Executive announced in the 2025 policy address that restaurant operators may apply for permission to allow dogs to enter their food premises, so-called dog emission permission. This initiative responds to public aspirations. It also help the sector tap new business opportunities. In drawing up this initiative, we followed 4 principles. First, providing choice. This regulation was enacted decades ago, as the chair just now explained, some 30 years ago. In terms of public acceptance, there are diverse views. So we must give a chance for patrons and restaurant operators to choose how they should operate. And that is why for those with permission, the signages should be displayed so as to allow the public to make an informed choice. The second principle is to give priority to safety and environmental hygiene. We will introduce legislative amendments and impose necessary additional license conditions. We also allow flexibility for restaurant operators to devise the most suitable arrangements. The third principle is to minimize compliance costs for the trade. The additional license conditions will not require the installation of major equipment. Instead, we'll only charge a fee of $140 for the additional license conditions to be added to the existing licenses. The fourth principle is to take small steps for prudent implementation. Now, this regulation prohibiting dogs to enter food premises has been in effect for over 30 years. I think we need to start with taking small steps so as to make sure that the whole society can adapt to the change. So in the first phase, we will only implement it in a small scale and in a prudent manner, and that means only 3 to 5% of all restaurants will be given permission. The public will still have a choice. Now I come to explain the proposed legislative amendments and the regulatory framework. the FEHD will draw up a set of guidelines on called Guidelines on Good Practices and Behavior to cater for the needs for restaurants with different layout, staff deployment, and mode of operation. The guidelines will include, for example, whether a cap should be imposed on the number of dogs, whether you'd recommend that each patron brings in only 2 dogs, and that perhaps you should not allow dogs to take the seat of human being, and then there should also be a dog-friendly zone, etc. Restaurant operators can make their own arrangements in light of their circumstances. Now, about legislative amendments, we need to protect patrons, staffers, as well as animal safety. We also need to ensure food hygiene, and that is why we've made adjustments or amendments to the legislation. At the same time, for smaller smaller restaurants, because they come in a smaller size, and that the aisles are rather narrow, staffers are required to bring in and out hot food, so there'll be a higher level of public risk. And as such, for these restaurants, we impose more stringent requirements. As mentioned, apart from a blind dog or dog for law enforcement, permission must first be sought for any dog to be brought into the food premises. Now, subject to the meeting the relevant requirements, dogs will be allowed in. The first one is as set out in paragraph 7 of the electoral brief, and that is, a permission is granted by the Director of Food and Environmental Hygiene in respect of the food premises for allowing dogs to enter. Second, the dog entering the food premises is not a fighting dog or a known dangerous dog. For fighting dog or known dangerous dog, you'll find clear definition in the Dangerous Dogs Ordinance. The breeds only account for a small number, and that is 21 for fighting dogs and 18 for dangerous dogs. So we have a lot of different breeds in Hong Kong, and that accounts for only a very small percentage. Third, at all times when the dog is present on the food premises, the dog is on a leash of not more than 1.5 meters in length, either securely held by an adult or securely tied to a fixture. Fourthly, the dog is not present in a food room at any time when it is present on the food premises. Food room is usually what we call the kitchen. It's where cooking takes place and where food is prepared. This is important because we don't want animals' presence in the food preparation process. So the requirements apply to restaurant operators as well as the person bringing in dogs onto the food premises. As mentioned just now, the current maximum penalty is one of a level 3 fine, imprisonment of 3 months, as well as a daily fine of $300. Our legislative amendments stipulate that it is a defense if a person can establish that they had a reasonable excuse for the contravention. I have covered the legislative amendments. I will now come to license conditions. The FEHD will impose additional license conditions as empowered by the law. And as explained just now, we require clear signage to be posted at a conspicuous place so that customers will have a clear idea that this is a dog admission permitted restaurant. I will now give the floor to my colleague to give you more details. The permission will come with a unique ID number. That is the restaurant license with the additional licensing conditions, and this will be posted at a conspicuous place at the entrance of the food premises. To ensure food hygiene, the license condition also stipulates that there is a clear separation between food and utensils for food and those for dogs. But it's not the case that dogs are not allowed to eat on the food premises. In fact, pre-packaged dog food may be provided, and one-off non-plastic utensils may be provided to these dogs as well. We also put in place another requirement. If the dog soils the area, the affected area should be thoroughly cleansed and disinfected immediately to maintain cleanliness. There are also additional license conditions to protect the safety of customers, staff, and dogs. For example, poisonous baits or rodent trapping devices should be kept out of reach of dogs, and also no open cooking or heating of food on dining tables should be allowed. So these are license conditions.
As mentioned, we will also prepare guidelines for reference. Regarding the regulatory framework, actually we have done rounds of consultation. As mentioned by the chairman, we have received wide support. Finally, I would like to share with you the timetable. Upon the scrutinization of the electrical, we plan to commence the amendments by 8th of May. Immediately, interested parties can join our briefing section. And we will also invite parties like the Hong Kong Federation of Insurers as well as the Institute of Shopping Center Management to share with the staff and restaurant owners regarding points to note. After the consultation, around end of May, we will start to receive application. If we have more than the maximum capacity allowed, that is more than 500 or 1,000, the decision will be made by ballot. By mid of this year, we will be approving all these new licenses. In the meantime, FEHD will continue to roll out programs like announcements in the public interest and other publicity. And in July, on one day, the first batch of approved dog admission permitted restaurants will start to allow dogs into the premises. So these are the arrangements for the first phase. If the operation finds smooth, within 6 months, we will roll out the application for the second phase. Thank you, Chair Lady. Thank you. We have sufficient time for a discussion. However, to have a proper time management, I would allow 4 minutes for question and answers include. If needed, we will open for second round. Let me read out the order. Yang Wen-kit, Christine Fong, Lam Chen-sing, Adrian Ho, Kenneth Fogg, Dennis Long, Stephen Ho, Peter Douglas Kuhn, Jonathan Long, and Judy Chan. Mr. Yang Wen-kit. Thank you, Chair Lady. First of all, I very much support this amendment regulations. I also agree with its principles, that is to give options and to roll out in small steps manner. It is very prudent. However, I do have certain comments. In the regulations, if you contradict with the conditions, there will be penalty. Or you might be suspended from your license if you have found to have any contraventions to the conditions. But it really depends on the code of practice. If you're in contradiction of the code of practice, will there be any penalties? I believe this is rather important because the conditions of the license are very clear. Upon reading, you will certainly know what will cause a breach of the conditions. We do understand about the fines and other punishments. But in other aspects, we really rely on self-monitoring. And you also have to think it through. For example, the size of the restaurants and the number of dogs allowed, it has to be included in the guidelines. If it is not clear, if you rely on the restaurant only to take care of that, maybe we would turn this into something sour. Therefore, I believe that we have to keep monitoring. Of course, now you are talking about the premises with 20 meters square or below cannot allow dogs. Let's say the premises has an area of 25 meters square. Excluding kitchen and other locations, how many dogs in total can be allowed? Without a specific guidelines, I am afraid that a lot of controversies will occur, and it is undesirable for the rolling out of policies. About the application of premise with 20 meters square, there are certain restaurants who have outdoor seatings. They may have a large area of outdoor seating. Will this be also considered? We are not just considering the actual area of the restaurant. Is that correct? I hope that there will be rooms for improvement. In paragraph 15, it's mentioned that, well, for some more mature pet-friendly facilities of shopping malls or restaurants with outdoor seatings, no priorities will be given to them. But it is very important if they do have appropriate conditions. I believe that you should allow them to do so in the first phase so that you can collect more opinions and to improve in the second phase. If you give approval to those located in an undesirable environment, it may not be a good thing for your policy. Thank you, Mr. Yang. Thank you for your support. You have also provided us with a lot of useful comments. Let's talk about the target of the Code of Practice. Regarding the conditions on safeguarding food safety or animals, it will be either included in the legislature or in the license conditions. So for the Code of Practice, I believe that these are the areas that can be taken as a reference of the food premises. As you mentioned, how many dogs specifically can be allowed into a restaurant? This is something important. Actually, we do have experiences because restaurants may be serving different food. Some are serving some light refreshment. Some are serving some like formal dishes. Therefore, in terms of the layout and the type of food that they are serving, they all varies. That's why they can allow for different numbers of dogs. That's why we do not want to specify it. However, guidelines were provided. When you determine the numbers allowed, you should consider these factors so that it can give them some flexibility. Mr. Yang also mentioned about the outdoor areas of the food premises. Well, actually, when we set the ceiling up 20 meters square, we have already included the OSA. You also comment on the priorities given. For example, restaurants located in malls with pet-friendly facilities. Actually, you have consulted the industry in this regard. Well, the comments differ. The mainstream restaurant owners believe that these kind of pet-friendly facilities have better operation conditions. However, whether or not individual restaurants are appropriate for such arrangements are not directly related. For example, if there is a restaurant that is not in the West Kowloon district or not in Cheung Kwan-o, but they have a lot of experience, they have some very mature conditions and ideal location. Since they believe that the two factors are not directly related, they prefer an open and fair ballot for making decisions. But you have put it right. If shopping malls prohibit the entrance of dogs, it will be meaningless for them to have this permission. Therefore, in the application, let's say the restaurant is located within a mall, we would first inquire if that mall or that particular building would allow the entrance of dogs first. Thank you. Next, Ms. Christine Fong. Thank you, Chair Lady. Thank you for introducing these amendments in negative vetting. That is the Food Business Amendments 2026. Will you consider about expanding the list of fighting dogs? Just now, the administration has mentioned that there are 21 fighting dogs and also some dangerous dogs. However, staff who work in the restaurant or the patrons sharing the same space in the restaurant might not be able to distinguish the types of fighting dogs. Would there be a set of information pack provided so that they will have some clearer guidelines? Second, would you expand the scope of fighting dogs? Of course, today we have decided to welcome written submission. Well, the list of fighting dogs was established a while ago. Will there be any more dangerous breeds that might affect the operation of restaurants? In the writing, you also mentioned that they have to be tied with leash not shorter than 1.5 meter. I am a dog owner myself. Sometimes they can behave very well, but sometimes when they are not behaving, it would be quite difficult to be controlled. Let's say there are some noise nuisance. If they are barking against each other, it might affect the whole restaurant. Would there be considerations about putting on the muzzlers? How can we create a harmonious vibe in the restaurant so that this policy can be more long-lasting? You also mentioned about OSA, outside seating area. We find a lot of restaurants in Cheng Kung O, Sai Kung, even West Kowloon district. Well, I hope that there will be some facilitation in this regard. How can we speed up the approval of? Can we speed up the approval procedures? If there are dogs allowed in the outside seating area, would there be a boundary being drawn in the restaurant so that the dog owners can take proper care of the dogs? It can also prevent the restaurant from expanding their own areas into other spaces. Thank you. Thank you. Your questions, Ms. Christine Fong. Let's first talk about fighting dogs and the non-dangerous dogs. As mentioned, actually there are less than 40 breeds that fall into these two categories. And you put it correctly. In related ordinances, there are 4 types of fighting dogs with some mixed breeds. Is it easy to be identified? I can tell you with certainty. The legislature has stipulated that these 2 dogs has to put on this collar with the color of red and yellow for identification. If the dog owners did not put on the collar, it would be fined at level 4 and also imprisonment of 6 months. A maximum. Depending on if it is a dangerous dog or a fighting dog. Therefore, there are already stipulations in the legislature regarding the identification of dogs. As Ms. Fong has mentioned, we will provide a pack of information and some online information. We will put it on the website of FEHD so that the patrons of restaurants and the citizens can take reference. Regarding the putting on of mufflers, well, we do understand sometimes the dog will have some very exciting interactions between them, but it might not endanger food safety or our own safety. Therefore, in the code of practice or the good practice guidelines, we will provide it to both the restaurant owners as well as the restaurant patrons. We will suggest them to carry out certain measures to reduce the nuisance. If they are barking vigorously, maybe we can take it out. Just like when the babies are crying, then the parents would take them away for a bit as well. I believe that it can be properly handled. Finally, regarding the expansion of the list of fighting dogs, we will consider it further on.
I will.
Let me remind members that you definitely have the second or third round to speak. So if you've asked 3 questions in just 4 minutes, then those waiting to speak may not have a chance to put their questions. So please make sure you finish what you have to say in 4 minutes so that you can have another round very soon. Mr. Lam Chun Sing, I'm concerned about staffers. Section 10B refers to persons engaging in food business, and that is a very broad definition. covering not only the licensee but also the employer as well as frontline staff. So let's say if a customer brings in a dog or a dangerous dog or fighting dog not wearing the specified collar, then who should be held liable? Is it the licensee, the manager, or the frontline staff? Because they may put up the excuse that the frontline staff should know as they are trained. So under what circumstances would frontline staff members be liable? And in some circumstances, an employer or restaurant operator, even frontline staff, have adopted all the measures. But after all, dogs are dogs. There might be a chance that the dogs might hop onto the table and that pictures may be taken. Who ultimately should be responsible? Is it the restaurant or the owner? And also about the defense as set out in the legal advisor's letter. Can you explain that point? For traditional restaurants, some restaurant staff may not be used to being with dogs in the same space. So these staff members may need to be redeployed. Another point is about OSH, Occupational Safety and Health. Now, the FEHD requires restaurant managers to arrange for their staff to take up courses relating to food, hygiene, or health inspection. So will you include the elements of allowing dogs onto food premises in your relevant courses so that managers, employers, and frontline staff will adapt better to the new regulation? Yes. Thank you, Chair. Thank you, Mr. Lam, for your comments about a person engaging in food business. This applies to anyone under the existing law as long as they meet the definition. So the FEHD has taken law enforcement actions before. And also, like Mr. Lam said, in light of different circumstances, the licensee, manager, or even frontline staff may be held liable. Our law enforcement officers of the FHD are very experienced. They will consider the circumstances before holding anyone liable. The next point is about employees sharing the same space with dogs. Now, we've heard the comments that some of these staffers may not be used to having dogs around, and that the operators should be compassionate in such circumstances. We'll definitely follow up on that and include this point in the guidelines. Mr. Adrian Ho. Thank you, Chair. I have 2 dogs and 2 cats, so I strongly support this initiative. Policy-wise, I have 2 questions. First, about the contravention of additional license conditions. Do you require an FEHC officer to witness such contravention before initiating prosecution? Would you accept, for example, the video recording made by somebody with a mobile phone as evidence? Will you take law enforcement action based on this piece of evidence? And what are the criteria? The next point is about resources for this additional task. The FEHD at the moment already has a lot on its plate. So how do you make sure that sufficient resources are allocated for inspections and supervision? Now, in the event of an accident happening on the food premises, say the dog biting somebody, then can you tell us who should be held liable? Is it the restaurant operator or the owner of the dogs? And how does one file a claim? And will the government require that the third-person liability insurance be taken out by the permitted restaurants to protect customers as well as staff members? Thank you, Chair. Thank you, Mr. Ho, for the comments. On law enforcement, I will give the floor to Deputy Director, but let me first address other points. That is whether additional resources will be given to the LVHD. This new task will be supported by existing resources. Inspecting food premises fall within the scope of the daily duties of our LVHD staff. Now, after granting the dog admission permissions to some restaurants, there will be some briefing sessions for the permit holders to know more about the conditions. Now, about dog biting incidents, who should be held liable? The law clearly stipulates that the person who should keep the dog under control will be held criminally liable and will be subject to a level 3 fine on conviction, subject to a reasonable excuse defense. In the guidelines, we will provide explanation as to how the restaurant operator should deal with a dispute. Now, in fact, dispute is not something new when it comes to restaurants. I'm sure you know that every now and then we do see disputes in restaurants, and our operators have experience of handling disputes. On insurance, we're not going to require each restaurant to take out additional insurance policy. They all have their own insurance coverage with varying terms and conditions. In fact, we had a meeting with the Federation of Hong Kong Federation of Insurers, and we also share the insight with the sector. We will advise the restaurant operators to seek advice from their own insurers on insurance coverage. Mr. Liu. In fact, when it comes to law enforcement action by the FEHD, we're not confined to just this piece of regulation about dogs. Our frontline officers will conduct observation and evidence gathering at the scene and consider the overall circumstances and in deciding whether there is a contravention. So like Mr. Adrian Ho said, if we receive a clip from a member of the public, it will be used for reference. We will ask our staff to go to that particular restaurant and make observation to see if there is a contravention before taking law enforcement action. Now, at the moment, we also receive photos showing disputes in restaurants, so the same approach will be applied. Our frontline officers will still go there and collect evidence. Next, Mr. Kenneth Fok. I support the direction of this policy and the 4 principles. With smooth implementation, I would definitely support this policy. My question is this. For the first phase, 500 or 1,000 permissions will be granted through balloting. Will you consider evening out these permissions across 18 districts? Will they be over-concentrated in some particular districts? So, for example, would you first specify a particular number of ballots in all of the 18 districts before leaving the remaining 400 to some particular districts? Now, you mentioned that in the first phase, 500 to 1,000 permissions will be granted, and this is because of the outcome of the consultation. It's only a small amount comparing to the overall number, so that's 3 to 5% of all restaurants. The other point is that hot pot shops with open flame cooking or heating of food on the dining table will not be allowed to apply for safety reasons. But some restaurants may not call themselves hot pot restaurants, but they do have the option of serving such food on dining tables. Will you require these restaurants to remove the items from the menu before they apply? So that's a rather specific question. The other question is about law enforcement, as Mr. Adrian Ho already asked. It seems that the FEHD now takes a passive approach, is complaint-based. Will you conduct inspection or spot checks more proactively to make sure that at least in the first phase there will not be a lot of contraventions? Yes. Thank you, Chair. Thank you, Member, for the comments. I thank Mr. Fogg for your support. Our thoughts on balloting are these. We want to take a straightforward approach, enjoying the restaurants that will receive the permission. We believe a level playing field can be provided, and this is limited to the first phase. We'll roll out the second phase 6 months or so after the implementation of the first one. There should not be a significant impact. Mr. Fogg just now referred to hot pot restaurants being ineligible for application, and he also asked, for example, whether other food items served by the restaurant will be allowed. In fact, according to the proposal, these restaurants will not be allowed to serve food that require open flame or heating on the dining table. So if this restaurant seeks permission for dog emission, then say if it's mutton stew, then it should be thoroughly cooked instead of using heating device on the dining table when it's served. Mr. Liu, about contravention, our law enforcement officers take action to ensure that remedial actions are taken, but we also act on our own, and that means we conduct inspections frequently, especially for dog for restaurants with dog emission permission. Now, at the teething stage, we understand that restaurants may need time to adapt to the new arrangement, so we'll have regard to the overall circumstances. If the breach is serious, and then definitely handle it, and we will conduct frequent inspections and maintain close liaison with the restaurants. Next, Mr. Dennis Leung. Thank you, Chair. I understand that restaurants are required to put up posters or signage to show customers that this is a dog emission permitted restaurant. But at the moment, there are also a lot of notices, posters already posted up at the entrance of restaurants. It may not be easy for customers to see. So will you ask the restaurant operators to use illuminated signs, just like the police flashing lights in red and blue? Will the department consider imposing this requirement for easy identification? The next question is about restaurants not in shopping malls but at grade or upstairs. Can you tell us if the application criteria remain the same? The third point is about some special devices for pets, because for some pets they may be tied to just the post or the leg of a table or chair. So can you tell us whether tests will be done or whether criteria will be drawn up as to the type of fixture? My last question is about disputes on scene. Will the department take a special approach? Because, say, there may be special squads set up in different districts so that in the event of a dispute, this squad will arrive on scene in 4 minutes to handle the dispute. in terms of the duties for our FEHD officers, will there be any amendments? Can you tell us the progress?
Deputy Secretary, thank you, Chair Lady, and thank you for your question, Mr. Dennis Long. First, regarding the signage of the FEHD, we will take it into considerations. All the approved food premises will be shown on a list on our designated website. I would like to invite Mr. Yu to explain to you further about the next item. As for the fixture, can it be fixed to the table or just a chair? Actually, it is not. We have to see if that particular table or chair is a fixture. In the legislature, we have stipulated that it has to be tied to a fixture. That is, it is immovable, it is fixed. If we're just talking about a movable table or chair, then it would not be something stable enough. But there are certain chairs or benches that are fixed onto the ground. If it is immovable, then you can tie the dog to such fixtures. Colleagues from FEHD will discuss the license conditions with each and every approved restaurants. It will be uploaded to our website, and it will also be mentioned in our briefing section in order to meet the demands. Mr. Yu, about law enforcement. Yes, as mentioned by Deputy Secretary, during the application period, we would require the applicant to make declarations to see if that premise allows dogs. If they are located in a commercial building, they need to consult the management company or the building owner to see if there is any restrictions in that particular building regarding dog permission. The point is that we don't want to see any waste of quota if that applicant is located in a building that does not permit the entrance of dog. When you asked about the special duty squad, actually we are planning to put together some designated team in order to execute related duties, so that our staff will be familiar about the certain requirements. We also hope that they will have some long-term and close communications with the food premises, so that when clarifications or handling is required, it will be more smoothly. It will be handled more smoothly. Next, Deputy Chairman Stephen Ho. Thank you. As time evolves, we believe that it is a trend for us to allow dogs into restaurants. The legislature also protects those who do not want to share meals with dogs. But still, we are very concerned the potential conflicts that we might have in the future. As some members have mentioned about responsibility, which concerns fighting dogs and non-dangerous dogs. Shall they be allowed to enter into the restaurant? Of course, they shouldn't. However, in paragraph 7b, you said that in paragraph 7, we could not knowingly suffer or allow such dogs into the restaurants. Just now, members also mentioned about trainings. Because there are only 40 odd breeds of fighting dogs or non-dangerous dogs, it will be quite difficult for staff to determine one breed from another. When there is an indictment in the future, then in the court, it will be very difficult for us to argue whether the staff has been trained or not. These are some very narrow topics. It shall be stipulated that that is the responsibility of the dog owner. Second, about the mode of operation. Well, now we are talking about allowing dog owners to bring the dog with them. But surely there will be loopholes that will be taken advantage of. I will start a restaurant that specifically showing dogs. We will showcase the 8 dogs that we keep so that patrons can come and share meals together with the dogs. they may even make up different stories. They would say that, well, I have taken in certain stray dogs. I have cleansed them. I am keeping them well. And now you can come and share meals with them. In the legislature, you said that the dog owners can only bring in 2 dogs. How about the licensing? How about the restaurant owners? According to paragraph 7A to D, it seems to be allowed. Would such loopholes be permitted? Finally, the first questions from Mr. Yang. I really hope that you can control the dogs to be restricted in certain areas and also the maximum numbers of dogs allowed. For instance, within 2, 4, 8 square meters, there should be only 1 dog allowed. Because people would think that they can handle it, or they would think that it's just a short period of time. They overestimate their power over the control of dogs. Therefore, that should be a minimum requirement. Deputy Secretary, thank you. Thank you for your question, Deputy Chairman. First of all, thank you for your support. As you have mentioned, should the staff or the person in charge be familiar with the appearance of fighting dogs and dangerous dogs? I don't think it is reasonable. In existing legislature, the known dangerous dogs and fighting dogs are required to put on an identifying collar. It is very clear. If the dog owner failed to do so, the dog owner will be fined or even imprisoned. If restaurant owners or frontline staff see such collar, they will know for sure that it is a dangerous dog. Apart from that, they also are required to put on mufflers. These are other requirements from the legislature. The dog owners is well aware of that because it is stipulated in the license. Let's say a frontline staff spot a dog without such collar. If they are worried, actually, the staff can go and ask. If necessary, the staff can require the dog owners to show the electronic dog license. Actually, on the website of FEHD, it can be accessed through IM Smart app if the dog owners refuse to do so because we cannot make it mandatory. If in doubt, the restaurant owner can refuse the patronage. If there is no collar found on the dog, and if the restaurant owners unknowingly allow such dogs into their premises, judging from individual conditions, they may or may not need to show their responsibilities. Second, Deputy Chairman also mentioned that nowadays we have a cat's cafe. Would there be dog's cafe in the future? In other words, the dogs are not brought in by the patrons. It was kept by the restaurant owners. In existing legislature, no dogs can be allowed unless the newly established conditions are fulfilled. If permission is granted by the FEH, they can actually do that. As for the limits of number of dogs allowed in certain square meters, at the moment, we are considering to include such recommendations in our guidelines. That is, 2 dogs per patrons. That is what we recommended. I don't want to take up too much time, but the response of the second question is way too simple. That means you allowed for dog restaurant. Is that your original intent? Deputy Secretary, maybe you can elaborate on this. As long as they can fulfill the conditions, they can do it. Because there needs to be leash, even for the cat cafe. They also has to keep it on leash. It has to be kept by an adult. At all times, they cannot enter into the food room. Also, it also have to fulfill conditions like the licensing requirements as well as food safety as well as animal welfare requirement. Thank you. Next, Reverend Peter Douglas Kuhn. Shelley, I want to first show my support, but I want to have a follow-up questions about the cat or dog cafe. Since we now have cat cafe, why can't we have dog cafe? The most important thing is people can have options. Well, because there has to be leash and there are a lot of conditions. In other words, it would be very difficult for them to operate a dog cafe. In other countries, there are dog cafes in operations, but maybe the dogs are well behaved. The most important thing is for people to have options. Perhaps you can consider issuing special license for a dog cafe. Then it is another channel of food businesses because we need to boost tourism. Maybe there are people who love dogs, but they can't keep one. Let's say they live in a public housing estate, but are very interested in checking out the dogs, and they can patronize those dog cafes. I think it is one possibility that we can consider. I also want to ask about the teppanyaki restaurants. Even in the diners, there will be food serving on hot stills. Even the Korean restaurant would serve food in bowls that are heated. Can we suggest people to not order such food if they are bringing in dogs? Wouldn't it be simpler? Well, because there are different types of food. They might not be heating it instantly, but maybe there will be a piece of heated stone of up to 300 degrees that is served together with the food. So my suggestion is, if they are coming in with dogs, they should not order food that comes together with such utensils, or the restaurants can refuse to serve those food. It might be more practical. Thank you, Deputy Secretary, and thank you, Reverend Kuhn. Thank you, first of all, for your support. Regarding dog cafes, the society holds different views regarding that. The reason why we stipulate that there needs to be proper leash is that we want to protect the safety of the food, the dogs, as well as the restaurant patrons. Or because even the animals might get hurt if they move around vigorously because there is hot food. Therefore, they have to fulfill our requirement because it only requires the keepsake of an adult. If it is a dog cafe, then the staff can be in charge of that. Well, we will try to offer flexibility for the industry. We want to strike a good balance. We want to safeguard food safety as well as the safety of people while allowing flexibility for the industry. And you also mentioned about Korean rice bowls served in heated stone bowls. Well, in our existing regulations, we do have requirements excluding open flame or electric heating apparatus. We want to be clear about our regulations and to offer flexibility. We are referring to any heating equipment, so there might be open flame or electric heating apparatus. These are prohibited. You also mentioned about teppanyaki or some heated stone bowls. In our guidelines, we might recommend them to consider it very cautiously or to avoid serving those food altogether.
Mr. Jonathan Leung, I try not to repeat what has been asked, Chair, as I understand. Dogs entering the premises should be held on a leash of not more than 1.5 meters in length and should be held by an adult or tied to a fixture. What about, the 16, 17-year-olds bringing in dogs? Will the restaurants be liable? Will the restaurants be required to check the IDs of the so-called adults holding the dog under control? Now, in fact, the Deputy Secretary just now explained the licensing condition, but according to the law, it seems that the restaurant is permitted to just having such an arrangement one day of the week. It seems to be the original intention. Can you explain that? Then the last point is this. The permission can be cancelled by application from the licensee. Now, how quickly will the cancellation be done? Yes. Thank you, Chair. Thank you, Mr. Leung, for the questions. First, regarding our requirements under the regulation, the dog in question should be held on a leash of not more than 1.5 meters in length and be held by an adult or tied to a fixture. So, if it's a minor at the age of 16 or 17 who wishes to bring in the dog on the food premises, then either the dog should be held by an adult on a leash or the dog should be securely tied to a fixture. We do allow flexibility. Second, for restaurants with dog admission permission, the signage should be posted at the entrance. At the same time, in light of the operating environment, operators can make their own arrangements. They can set their own rules, for example, only allowing pets in during certain hours or during certain days of the week. As for the endorsement or cancellation, I'll give the floor to the Deputy Director. The relevant procedure is quite straightforward. After we've received an application for cancellation, we follow up on it, and that means we amend the restaurant license and cancel the endorsement. It can be done within just a few days. Now, for the endorsement on the restaurant licenses, basically these endorsements will be automatically renewed along with the renewal of the restaurant license itself. No additional procedures are required. Next, Ms. Judy CHAN. I welcome the amendment regulation. This can help the catering sector tap new business opportunities. I have 3 questions. First, recently I went to a restaurant with an outside seating area. And then I see paper utensils being used, and I was told by the staff that it's a pet-friendly restaurant. So, pet owners nowadays know where these restaurants are available. That is, restaurants that would welcome pets at the OSA, and this is the so-called gray area. Now, my question is this. Will there be clear stipulation that if dogs remain outside at the OSA, a more relaxed approach will be taken rather than the stringent requirements imposed for the indoor seating area? About dog and cats cafe, basically, I often go to these cafes because my children are fond of cats. Now, their operation is like this. You are not allowed to pet the cats when you're eating, and only when you finish your meal will they start to allow cats to approach. After they've cleaned and disinfected the tables, will they give you the canned cat food, for example. But that's the case for cat cafes because cats are not required to be put on a leash. Say, if it happens in a dog's cafe, then the staffer will be required to hold the leash of the dog at all times, and that would be a totally different approach. There would be no fun at all. So will there be special treatment for dog face? My third point is this: if this dog becomes mischievous and bites a staff member, then would it be regarded as injury on duty? Is it a work injury? Because the employer may as well think that this is a responsibility of the dog owner and not the employer. Yes. Thank you, Ms. Chan, for the questions. About the outdoor seating area and the current perception that these areas are pet friendly, the legal advisor actually made a similar inquiry for, say, a food court that is outside. Would it be a dog admission permitted area? Now, the regulation framework works like this. Basically, we check if the area falls within the scope of regulation. If it falls within the scope of regulation and the scope of the restaurant license, then it will be subject to the regulation. Now, if this is part of the shopping mall, that this is not a place for, say, the delivery of meals and it's not managed by the restaurant operator, then it's not part of the regulation. About dog and cat cafes, first of all, I want to explain that this regulation prohibiting dogs on the food premises has been in effect for over 30 years. This regulation applies only to dogs but not to other animals for practical reasons, because dogs are in general larger than other pets, and that a dog bite could cause some very serious consequences comparing to other animal bites. So, from the perspective of protecting patrons, restaurant staffers, as well as the animals themselves, we have put forward this proposal, and that is dogs will be allowed as long as they are securely held or put under control. Now, 1.5 meter leash is actually an appropriate length. It's not really short. So I believe we have struck a balance. This is basically a safety consideration. As for the operating environment of restaurants, this is also crucial to determining whether it's a work injury. This is also subject to any agreement between the employer and the employees, and we will include that in the guidelines. Next, Mr. Perry. I support the amendment. I hope that this new initiative will facilitate dog owners in taking their dogs to restaurants, and that this initiative can bring more businesses to restaurants. I have questions on the implementation details. According to paragraph 10 of the paper, license conditions will be imposed to safeguard food hygiene. This is only reasonable. When it comes to actual implementation, can you elucidate? I think we need to discuss further what happens if there is a dispute between patrons and restaurants. The other point is, according to the same paragraph, in case of fouling of the premises by dog excrement, the restaurant operator must ensure the affected area is thoroughly cleansed and disinfected immediately to maintain cleanliness. So, it seems on the face of it, the restaurant operator will be responsible for cleaning up dog excrement. This is, of course, crucial to maintaining hygiene in the eatery. But as a responsible dog owner, I'm sure that something will be done. Can you specify in the guidelines, for example, whether restaurants will be able to charge a certain fee for cleaning up the area? after it's been soiled by a dog. And that dog owners can also clean up the place themselves. But will it be clean enough? Will it be thoroughly disinfected? And will this effort be accepted? I want an explanation from the administration. Yes, thank you, Mr. Yu, for the comments. Now about excrement. Definitely, it's for the dog owner to take care of the dogs. The restaurant operator's responsibility is to supply food to patrons. They must ensure that the food and the environment are clean. And this is the bottom line, and that is why we want restaurant operators to take this responsibility and ensure that the affected area is thoroughly cleansed and disinfected. During the consultation exercise, the sectors gave us feedback. In fact, they've made their own rules. They will do so in advance. For example, if the place is soiled, the patron will be required to pay a cleaning fee. And if you want to clean up the area yourself, this is all right, but subject to the agreement with the restaurant. So as long as there is clear communication between patrons and operators, it'll be all right. Next, Ms. Michelle Tang. I support the legislative amendment. In my whole life, I've been accompanied by dogs, and I'm also a very experienced volunteer. I have many friends who own dogs. So we welcome this initiative, allowing dogs in restaurants. At the same time, we must also have regard to how dog owners feel. We have, for example, very small restaurants in Hong Kong, and sometimes the dogs may shed a lot of hair, and that the air may be full of dog hair. So will it be necessary for restaurants to install air purifiers? Deputy Chair. Well, I thank Ms. Tang for the support. I'll give the floor to my colleague. I'm sure that Ms. Tang understands the goal is to ensure hygiene in the food establishments. We do not make it mandatory for air purifiers to be installed, but we will include these examples in the guidelines for restaurant operators to consider. Say for restaurants, they may make their own rules. They may, for example, only allow dogs at the OSAs, and if it's indoor, we will include this element in the guidelines. I'm the last one to speak. This regulation has not been amended for 30 years, and I support the amendment. Now, I think it's a discrimination against dogs because this regulation applies only to dogs. They are not allowed on food premises. So the word dog should be deleted. Second, after the discussion by the panel last time, I received feedback feedback from those who do not welcome dogs onto food premises. I want to emphasize that the priority is to give a choice to operators and patrons. Now, in fact, the permission will only be given to a small number of restaurants in Hong Kong. Now, if there is a concern that dogs may bring allergy or danger, and if you don't like that, you can choose not to go. We are an inclusive society. We're not asking all restaurants to open up to the admission of dogs. So it's still subject to your personal preference. So about this signage of dog admission permission. It won't be difficult to display this signage, which is a copy. Will there be a QR code available? How do you make sure that this is an authentic permit? And where should it be placed so that it will be conspicuous enough for everybody to see? Second point, now in fact, you should provide a definition of dogs in your regulation, because if you're a dog owner, you know that the dogs are required to be implanted with a chip and receive all the jabs. But at the same time, we do have people smuggling dogs into Hong Kong. So in your regulation, you should stipulate that by dogs you refer to dogs which have received the necessary vaccines and implanted with chips according to the AFCD requirements. The dogs should be dewormed as well. But if it's an illegally imported dog, then that's another matter. So perhaps you should set out these requirements in your license. And also the age of dogs, because the dog cannot receive the vaccine jabs until it reaches a certain age. So you should spell these things out.
Deputy Secretary, thank you, Chair Lady, for your support. First, let me respond to your questions concerning the signage. We will put the license number of that food premise on this signage. It is a unique number. It can be found at the left bottom corner. It is a unique number, as I said. And it is the license number that he is or she is holding. And also there will be inspections by the staff of FEHD, so that there will not be any illicit signage. We will also include in the license conditions that if you are not permitted, you cannot display any similar signage. And since there is a unique number, if it is a fake signage, maybe we can also prosecute you with the offense of the falsification of documents. Second, will there be any stipulations regarding dogs? The definition of dogs would require that it has to be licensed. Well, actually, any dogs up to the age of 5 months has to receive license and to receive vaccination. If they breach such regulations, they will be fined at a level 3. So I don't think it is required in this particular ordinance. In terms of law enforcement and the operation of the food premise, I believe the regulations have to be simple and direct. Well, if you need to check if there is any chips, then maybe not any restaurant can own such machine or know how to inspect the chips on the dogs. If it is regulated by other registration already. Second, if we have already spelled out protection to safeguard the safety of other patrons and the staff, which includes it has to be held by leash not or shorter than 1.5 meter, I believe that this is basically serving the purpose. Thank you, Chair Lady. Next, in Section 10b(3), it says that the dog can not enter the food room. That is, it can be allowed in the food premises except for the food room. Have you already stricken an optimal balance in being clear about your regulations as well as offering flexibility? Because you said that food room normally refers to the space that take care of the food. I have missed out one point. In the first phase, we only accept 500 to 1,000 applications, which takes around 3 to 5% out of the 17,000 of food premises in Hong Kong. If there are members of the public who do not wish to dine with dogs, they do have a lot of options. Responding to Mr. Chen Pok-chi, thank you for your questions. Regarding food room, Actually, we are referring to the rooms where food is handled, that is, kitchens. Since kitchen is where food prepared for the diner or the patrons, we do have higher regulations regarding its hygiene. We would not allow dogs or any other animals from entering into that space. We will have second round of questions right now. Please press the button if needed. I am not going to repeat the order. First, Mr. Yang Wen-kit. Thank you, Chair Lady. I have a follow-up question about the guidelines for good practices. This guideline is very important to the proper execution. Can these guidelines on good practices be included into the license conditions? Because if you just give it to the discretion of the restaurant owners, then maybe the effect will be very different. Let's say there is a restaurant with just 30 meters square. Although you said that you can allow 2 dogs per patrons, if we allow a number of patrons to bring in dogs, it will be undesirable to the environment of the restaurant as a whole. Would you be monitoring the guidelines of the food practices? If you include that as your license conditions, it will be more reasonable. If you just leave it to their own discretions, maybe it will be quite chaotic in the future. Second, about taking of ballots. If the restaurant is coming with an outdoor seating area, or if it is located in a pet-friendly shopping malls, would they be given priority? Well, just like the ballot for people who apply for public housing estates, we will always give priority. Will there be any conditions that you provide so that you will offer them priority? My worry is that although you are only allowing 3% of restaurants to apply, but maybe people would just apply for it no matter what, because it is not costing them a lot. It's just 140. Would you consider that? Finally, about training. A lot of people in the catering businesses may not know how to handle dogs. When situations happen, they may not know how to take care of it properly. Well, because if these regulations allow people to start up more new restaurants, providing additional employment opportunities for them, would you put together certain training courses so that the staff will be more experienced? It's also a protection to the safety of the staff. Thank you. Thank you for your comments, Mr. Yan. Let me share a little bit more about the guidelines. Regarding the guidelines on good practices and behavior, it will be compiled by FEHD so that the restaurants and the patrons can take reference of it. The restaurant can also put together their own house rules. Just now, Mr. Yang said, should we scrutinize also the house rules before approving their applications? Regarding all the basic safety rules and food safety rules are already covered by other ordinances, or it will be already covered by the license conditions. Staff from FEHD will look into it and to share with them about the statutory requirements once they successfully applied for it. There will also be inspections. I understand your concerns. Well, but this is just the first phase. We will continue to optimize our execution according to the actual situations. You also mentioned about giving of priority at ballot. As we consult the industry, they said that they prefer a fair and simple ballot. You also mentioned about the adding of credits. I believe that we will take it into consideration. As said, it is just the first phase. If it operates smoothly, we will optimize our arrangements and roll out the second phase. You also mentioned about staff training. I completely agree with you. In our sharing and briefing section, we will invite Association for Animal Protections to come and share with us, and we will also upload related information onto the website. We will prepare videos that will be animal experts sharing tips on caring for animals. You also mentioned if such information can be included in the future training. This is something that we will be actively considering. Thank you. Next, Mr. Adrian Ho. Thank you, Chair Lady. I very much agree with what Chair Lady have said. Every pet owner are required by law to receive license, but there will always be people who is taking advantage of the loopholes. Taking the Pet Expo as an example. Well, the Deputy Secretary said that not all restaurants would have the scanner to check the existence of a chip. Well, but when we are talking about the Pet Expo, all the participants who enter into the expo are required to show the vaccination record. You might be a license holder, but you have a lot of vaccinations that are required, including rabies, etc. It is a protection for the pet owners, the staff at the restaurants, the patrons, as well as the pet. How about we require them to take the vaccination record with them? At least they have to display the vaccination record so that we know that you are fully vaccinated. Second, the administration said that we hope that we can open for second round of application within 6 months of the rolling out of first phase. Are there any practical indicators? Would there be the number of cases of a contravention, the number of restaurants that exit the plan, the level of satisfaction of the general public, etc.? Thank you very much for your comments, Mr. Adrian Ho. I will consider your suggestion of the inspection of vaccination record. You also share a lot of metrics that are very useful. We will look at the number of complaints, how it is being operated, as well as the feedback from the general public and the restaurants. During inspection, staff from FEHD will also be collecting different data. We'll also be listening from all of you. That is how we can make our decision. Thank you. Next, Deputy Chairman, Mr. Stephen Ho. I appreciate the follow-up questions of other members. I am not against the operation of dog cafe. I just want to know that it is something that you're allowed because the industry might invest into it, they may start operating, but then you might go against it with a new legislature. There are also questions about the cat cafes. To a certain extent, some of them are operating in a very desirable manner, but some are not. I believe that you are aware of that. Are there any shortfalls in our legislature? Or are there shortfalls regarding your inspections? Or there are people who deliberately contravening your regulations, or they simply care too much. They want to take in all the stray cats that they see. Sometimes I will pose you with some extreme scenarios. Hope you will bear with me. Just now we talk about the different status of dogs. If they are below 5 months old, they may not be allowed because they are not vaccinated. Therefore, in my first round of questions, my first question is, would you require the staff to know if that is a fighting dog? Actually, it is not required because the dog owners should be prohibited from doing so. These are the details that are worth your consideration. We may not just be restricting on dangerous dogs or fighting dogs. There are actually areas that should not be the responsibility of the staff. Instead, it is the responsibility of the dog owners. In that case, it will be easier during the prosecution stage. In the future, maybe one day there will be certain contagious disease. My suggestion is that at any time you can put in place some special measures to prohibit dogs from eating at the restaurants. They have to put on mufflers at all time. Or because when there is bird flu, you will not allow people to touch the chicken. But of course, at the hawker store of the chicken, there needs to be some transitions. But if there is any contagious disease that may affect other dogs, in such an emergency case, how can you handle that? Well, 30 years ago, we see a widespread of rabies. I'm not sure if it will revive again. Recently, there are countries releasing number of casualties caused by rabies, and the number is not small. If we are not conducting our border control regarding animals properly, that might be the widespread of animal-related disease. When that happens, would there be any last resort measures that we can put in place?
Yes. Thank you, Chair. Thank you, Deputy Chair, for the questions. Now, Deputy Chair just now mentioned that permission may be granted for dog cafes as long as they meet the legal requirements. The second point, for dogs going into food premises, they'll be subject to license conditions. We'll draw on the operation experience and in future allow other restaurants to have additional license conditions in order to operate as animal cafes. Say one of the conditions is that for poisonous baits or pest rodent trapping devices, they should be kept out of reach, and this applies not only to dogs but cats as well. So that will be something in the next phase. The third point is about the conditions to allow dogs in restaurants. I fully agree with Deputy Chair that we want to keep things flexible and straightforward because the objective is to maintain harmony between human beings and pets. We also want to provide new business opportunities to restaurants. And restaurants are not the same as hospitals, for example. At the same time, we need to keep the bottom line, and that is to safeguard the food and environmental hygiene as well as protecting the safety of customers, employees, and other patrons, and animals as well. Deputy Chair also referred to some conditions requiring the patrons to be responsible. Now, it's not just the licensee that should be held accountable. For those managing the food premises and providing food for customers, including employees, they will be held liable as well. The last point is about epidemics and whether swift response will be given. Well, in general, the answer is yes, through emergency legislation and through invoking provisions relating to environmental hygiene and human health. Just like COVID pandemic, we were able to enact legislation quite expeditiously, and we can discuss this with the Department of Justice. I thank Deputy Chair for thinking ahead. Now, we're not only concerned about human-to-human diseases, but also diseases that spread among dogs. Mr. Jonathan Leung. Now, I want to ask another question for clarification. On the whole, I support the legislation. I hope that in the future we'll be able to promote the initiative to bring more business opportunities to restaurants. About guidelines, I have this question. The guidelines may include the maximum number of dogs on food premises and the checking of vaccination records. But if you include all the nitty-gritty, there'll be a lack of flexibility. The guidelines will serve more than reference. It will become another piece of regulation because we need flexibility. There are restaurants of different nature catering for different numbers of dogs. Some may only allow dogs to remain outside. And say if you go to a very famous restaurant in Taiping Shan Street, you may see that some patrons may bring 7 to 8 dogs at the same time. They are small dogs. They are quite obedient, but there are also dogs that look dangerous. They could be fighting dogs. If you stipulate the maximum number of dogs to be brought in a restaurant, then the restaurant operators will not enjoy flexibility. So I just want to make sure that there is flexibility for restaurants and that staffers should be trained to avoid disputes. I thank Mr. Leung for the support. In fact, we have maintained close liaison with the sector on the drawing up of the guidelines, and will continue to do so to make sure that the guidelines will remain useful without subjecting the sector to a straitjacket. Next, Ms. Christine Fong. Thank you, Chair. I'd like to pick up on my last question. Some dog owners will put their dogs on a stroller or carrier. Some may put them in bags. In fact, recently when I took the MTR, I saw somebody putting the dog in a bag that is entirely enclosed. About paragraph 11, requiring dogs to be put on a leash and tied to a fixture securely, then will the stroller be regarded as a fixture? Let's say if this owner holds the dog which is on a leash of 1.5 meters, then is it still permitted? I hope that the guidelines on good practices and behavior will include the specific details as well. The next point is that, for example, in Macau, their proposal entails a requirement, that is, dog owners should make sure that the dogs wear diapers when they go in restaurants, because dog owners may not be able to control when the dog will answer the call of nature. So requiring diapers be used will provide flexibility. And in the event of a dog bite incident in the past, the FEHD would follow up on the matter. Now, apart from fining the dog owner, the dog itself will have to be imprisoned, so to speak, and that means it will be kept at the AMC of the FEHD for some time, say a week or so. Now, for dogs which are not fighting dogs or dangerous dogs, but those which have bitten before, will there be a record? Will they be allowed in restaurants again? Yes. I thank Ms. Fong for the questions and comments to respond to cradles and strollers. In fact, the legal advisor put the same question to us. We propose putting the dog on a leash, having made reference to the relevant legislation on the control of dogs, because when it comes to strollers, they come in different designs and colors and layouts, and what is meant by properly keeping the dogs inside? What if the zipper loosens? What if the dog jumps out all of a sudden and hit a waiter with hot food in hand? It will cause danger. So we require the dog to be put on a leash whilst inside the restaurant. Now, if the dog remains in the stroller, and if the dog is on a leash and held by an adult, then it's entirely all right. So as long as the dog is on a leash and held by an adult, then yes, a stroller can be used. Now the next point is about answering the nature's call, and indeed Ms. Fong's observation is correct. The dog owner may not be able to control when the dog does so. But we also ask animal welfare experts. Is not good for the animal if we require the dog to wear a diaper or different dogs to wear diapers. So instead, we would advise restaurants to put some urinating pads on chairs, on the floors, and we do require that the affected area be thoroughly cleansed and disinfected immediately if it's soiled. Mr. Lam Chun Sing, 2 questions. Now, the restaurant's permission will be cancelled if 3 breaches are recorded. Not so much the restaurant license, but the dog admission permission will be cancelled. So this will affect restaurants that specialize in providing this kind of business. Is there a complaint handling mechanism? If somebody rings the department and lodges a complaint, how long does it take to investigate the matter? The next point is about staff members' responsibility. Now, I appreciate it's difficult for the DS to explain in each and every scenario whether somebody has breached the law, but at least can you tell us more details? For example, if a frontline staff member has adopted a series of measures, then very likely will this staff member be able to put up a defense and say, I do not allow the dog to hop onto the table, and I also cleanse the affected and soiled area for you, then I should not be caught responsible. Can you tell us more? Yes, thank you, Chair. On frontline law enforcement action, I will ask Mr. Yu to respond. And about contravening the license conditions, the FEHD adopts law enforcement criteria. There are criteria to follow for the officers to see if the license conditions have been met. 3 contraventions in 12 months. Now we're talking about actual contraventions, not complaints. When we receive a complaint or when we conduct an inspection, we will check if the license conditions are breached. And in such event, we will issue a warning letter to the restaurant in question stating the condition that has been breached, and we will put the warning on record. And if there are 3 such warnings in 12 months, we will invoke the procedures to cancel the dog admission permission. The FEHD's decision is subject to appeal. The operator may appeal to the LIAB.
First, I would like to seek your wisdom regarding a scenario. Now you're requiring dogs to be securely held by an adult with leash not shorter than 1.5 meters, or it has to be tied to a fixture. As the Deputy Secretary has stipulated it, that includes table or chairs that are mounted firmly onto the ground. However, for dog owners who used to go out, not all dogs are being held by leash. There are some smaller dogs that are kept in the carriers. They will enter into the premises with a carriers because dog owners need to dine. In the past, it will not be allowed. Well, if it is being kept in the carrier, it will be completely fine. But according to your legislature, do I have to securely hold it on the leash, I have to take it out from the carrier, because if it is kept in the carrier, it will be very secure and it will not be barking against each other. Well, of course, I understand the original intent of the legislature. However, as dog owners, you will surely understand that keeping a dog in a carrier is something very common. Would you consider in it? Well, why would we be required to take it out of the carrier? It seems quite weird. The legislature requires our acceptance. What would be your publicity strategies? Can you share more about your direction? How are you going to educate the public, be it the restaurant owners, the dog owners, even those who are not keeping a dog? They all need to be educated. When we had to scrutinize the ordinance, actually the content is very simple. However, apart from the legislation itself, there has to be license conditions as well as guidelines on good practice. Can you share with us the different penalties upon contravention? Well, if it is just a guideline, if there are contraventions on the guidelines for 4 to 6 times, would you consider a certain level of penalty the next time they renew the license? What would be the consequences of breaching the guidelines? Thank you. Let's first talk about the carriers. The reason why we regulated tying of leashes because at the moment, all the other ordinances has the same requirement in terms of securely keeping dogs. Truly, a lot of citizens will make use of strollers and carriers. However, their designs may vary. Sometimes it is with or without a cover. Sometimes the cover is a net, sometimes it's in other materials. But how can we make sure that the dogs are properly secured? There are surely a lot of different scenarios. In order to safeguard the safety of patrons and staffers, we believe that the requirement of use of leash is the most secure. We are not requiring the dog owners to take it out of the carriers, because if they are behaving very well in the carriers, we only need to apply the leash, and the adult has to be securely holding it. They can be kept in the carriers. It's completely fine. Our major concern is that sometimes when the smaller dogs are being stimulated, let's say they come across a friend, they might rush out of a carrier or they will jump around inside the carrier. You will not be able to keep it under control. But with a leash, you can do that. There might be other patrons who are just taking a walk with a carrier and not the leash. Then it has to depend on the operators of the restaurants. If they see it as a business opportunities, maybe they can prepare leash for rent at the restaurant. We will allow flexibility for the restaurants to operate on their own terms. Regarding publicity strategies, we will have 3 major group of audience. First, the catering industries. If they want to join the scheme, they would need to know what are the conditions, what are the mode of operations, and what are the requirements. Second, the staff. As members have mentioned, this is very important because we need to safeguard the safety as well as the knowledge that is required. Third, the public. They can be dog owners or not, but there needs to be public education so that they know that what are the restaurants that can allow the admission of dogs, and what are the legal requirements, and what are the guidelines of good practices. These are the 3 major areas of publicity. Regarding the contravention of guidelines, I would like to defer it to Deputy Director, Mr. Yu. As mentioned, a guideline is a guideline. As a dog admitting dogs, there might be considerations that they need to have. For example, the area, the types of food that you serve, your patronage. This is just a guideline, as said. The restaurants can exercise discretion to make their own decision. It will not be a breach of the guidelines. On the other hand, there are guidelines regarding the safety or hygiene of the restaurant. Well, of course, we already have the legislature and license conditions. In the future, if we believe that we need to strengthen the regulations in certain areas in the guidelines, we can include them in license conditions. Upon that, any breach of license conditions will be taken care of through the mechanism. But now we want to have the different levels. There are mandatory requirements that are spelled out in the license conditions and the legislature, and the guideline is just a guideline. Upon accumulation of experiences, maybe we can straighten the rules or to loosen it. I have a suggestion regarding publicity. We know that FEHD have your own website, but there are also some platform or portals that recommend restaurants. Can there be certain indications so that the citizens would know what options they have? I want to see if anyone needs to have a third round of questions. Nope. Legal advisor, any questions from you? Not at this moment. Thank you, Chair Lady. Originally, this meeting shall adjourn by 12:45, so we will not enter into the scrutinization of the legislature because there are still areas that we need to cover. If you would like to offer any amendments to the legislature and if you want us to consider it, then it needs to be submitted before 5 a.m. on 2nd of April, that is next Friday, so that we will be able to provide written submission in response to your draft. The administration can also offer the amendments. It shall be submitted as soon as possible for our considerations. Members need to understand our timetable. As our usual practice, we need to report it to the House Committee within the time frame. If there is no objection, then next week on the 1st of April, I will move this motion and to postpone it to the 6th of May 2026 Council meeting. If we successfully extend the deadlines, then it shall expire by the 6th of May. And the announcement of amendment is the 28th of April, and our reporting date to the House Committee is the 24th of April. If you have any questions, please feel free to pull it to us. Final item on our agenda today, any other business? If there is, well, there is no other business. In our next meeting, we will continue to scrutinize the legislation. Deputy Chairman, I would like to reserve certain rights because we might still have questions. But it would be good for us to complete the scrutinization of our next meeting. But we cannot make our decisions yet because we still need to go through the feedbacks. Certainly, there are members of this committee who have parallel meetings at this section. Before scrutinizing the legislature, we will allow questioning regarding the policy. We might be receiving other comments or written submission because there are members who are making recommendations to you. I hope that the administration can respond to them all before we scrutinize the legislature. There is no other business. This is the end of our meeting. Our next meeting will be conducted on the 10th of April, 2:30 p.m. Meeting adjourned.